Good morning. Good morning. It's Friday, March 29th, 2024. We are gathered here today on this Good Friday to cover the state versus Hannah Gutierrez. Hannah Gutierrez was recently convicted in New Mexico of involuntary manslaughter for the shooting death of cinematographer Helena Hutchins on the movie set of Rust. She was the armorer. She was in charge of the weapons. Alec Baldwin had the weapon. His trial is set to go forward in July 2024. So today we are covering the defense's motion for new trial. I have a lot of thoughts about the defense's motion for new trial, but the defense's motion for new trial essentially said, Your Honor, there's a new case. And obviously, Hannah Gutierrez gets a new trial because of this new case. Trust me, bro, it's fine. Today, I'm going to cover the state's response to that very briefly. I'm going to cover the defense's reply to the state's response very briefly. Then we are going to go to court. Court today is being held via Zoom or WebEx or Google Meet or whatever. So it is court over video today. And this is all leading up to Hannah's sentencing that is currently set for, let me make sure I get the date right on this, currently set for April 15th, 2024. The amount of court dates on my calendar, April 14th, 15th, and 16th, is BANANAS. It's a lot of court dates coming up at the beginning of April. We are getting into the very busy season with court. Just for a quick explainer, court seasons can run very akin to like school years because lots that work in the court system also have kids and stuff. Jurors have kids and stuff. So you will see a lull from like Thanksgiving to the middle of January, and then it will get very busy through the end of May. Then you will see kind of a lull over the summer, and then it will get very busy at like end of August, September, October, and then everybody's like, it's the holidays, and then you get into a lull again. So court definitely has this really cyclical schedule to when people want to go to trial. Some of that is because jurors get a little bit salty about being in trial over their spring break, Thanksgiving week, Christmas. I mean, it doesn't really matter for the jurors in like the I don't know, the Young Thug trial, because they're going to be in trial for like 2 years or something by the time they're done. But for most jurors, those time frames are when it's a little bit better to go to trial. So we're seeing that very busy season right now that's going to run off and on from, February through May, of lots of trials, lots of court dates, jamming everything in. And then at the end of May, everybody's going to be like, I have vacation scheduled, bye. And then the summer gets a little bit more difficult. So with all of that, we're going to run the intro. We're going to cover just those two quick responses. I've already covered the defense's motion. Maybe I'll pull it up just real quick so that you understand that the defense literally did not argue anything fact or law. He just said, new case, obviously new trial. But with that, law nerds, we're here on a very special Friday to go to court together. So let's roll.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Emily, have you shared your screen to pull up those documents? No, I was pulling up the chat because chat is bae, and we're always trying to make things easier for chat. And then I decided that I wanted to pull up her defense's emergency motion too. And so here we are. All right, let's pull up the defense's emergency motion for new trial. He's like, emergency, Your Honor, a new Supreme Court case happened. And when I say Supreme Court, I mean the Supreme Court, this is the state's response. I mean the Supreme Court of New Mexico, not the U.S. Supreme Court, just so we're clear on that. Where is my defendant's motion? No. I normally have them linked. Wait, nope, this is it. It's that long because he attached the response. All right. With all of that, chat, it is a Friday, so, Streaming on a Friday is special. Emergency motion for new trial and release. So he's arguing two things. He wants a new trial for Hannah because, trust me, bro, and he wants her released from custody. The New Mexico Supreme Court just issued its ruling in State of New Mexico versus Taylor. I read the entirety of that court decision on the stream where I covered this. So if you're interested there, we can go there. The heart of the argument is that any jury instruction, the heart of the defense's argument, any jury instruction using and or means new trial. I don't think that's what the court ruled at all. I think it's much more nuanced than that. We're going to get into the state's response. This is precisely the argument Ms. Gutierrez made in the jury instruction arguments. Remember, will you remember, if you do not make an objection at trial, you lose the ability to appeal and make further motions on it. You have to preserve the objections. This is one of the difficult things about being an attorney, is that when you are in trial, you are thinking of all the possibilities and trying to think down the road for everything that could be a problem. And you have to preserve those objections. Even if you're going to not object, and argue for a million years on it, you have to say, Your Honor, we object to that jury instruction on these grounds. You have to save the objection. You have to preserve the objection. It says these arguments were overruled and the state made the same error using the and or instruction. Where is the rest of the argument here? Because there isn't any. No argument on the law, no argument on the facts, no breaking down of the case. This jury instruction is virtually certain to result in the reversal of a trial conviction under the new Taylor opinion. False. False. It would be a manifest injustice to keep her incarcerated while further proceedings related to this important issue occur. Sir, okay. Okay, sir. We're going to go to the state's motion for that. The state's reply is only 7 pages long. We're not going to go through all of it. We're going to summarize it because the thing I love the most is getting to court. We're going to get to court and then we're going to get to your questions. But let's look briefly at the state's response to the defendant's emergency motion for new trial. All right. Let's see. Yes, I try to remember to take my links off of there because every now and then I get a very odd request for links. All right. Hannah Gutierrez, by and through her counsel, Mr. Bowles, made this motion. The United States and New Mexico constitutions, through the 14th Amendment, mandate unanimous jury verdicts in criminal cases. Okay. This requirement of unanimity was not respected in the involuntary manslaughter instructions. Was not respected in the involuntary manslaughter instructions given to the jury, and the special prosecutor specifically argued in closing. This is the defense's reply. This is not the state's reply. Hold on. Where did my state's reply go? And why is it missing? That's the defendant's reply. That can't be the state's reply. Emily, where did your motion go? We're going to have to swoop again. That's the reply to the state's response. Why is my state's response missing? Sorry, chat. It was, as I'm looking to how it got mislabeled, because it must have gotten mislabeled because I pulled it. We're going to go one more place to grab it real quick. And I apologize for the delay because that's embarrassing. But Emily's normally prepped. I had the link linked and now it's the wrong link. Has anyone ever clicked on one of my links on social media stories when I've linked the absolute wrong link? It's not like it's the first time that it's happened. So that's the defense's reply to the state's response. Ugh. Well, at least there's more than one place to pull it up from, so I don't have to worry about my filing system. All right, let's try take two. We'll fix it in post. State's response to defendant's emergency motion for new trial and release. Chat, there is no post. It's a live stream. I was just teasing. Let's see. The state of New Mexico, through special prosecutors, Jason Lewis, Carrie Morrissey, submit the following response. Defendant's threadbare motion. We just start with the insults right out the gate. Right out the gate. Defendant's threadbare motion requests a new trial based on the erroneous distillation and application of a recently issued New Mexico Supreme Court opinion. Not only does your motion suck, she says, your motion sucks and you misread the law. That's the state's take. Trust me, bro, we're not trusting you. Although the defendant's motion is thin on facts and argument, the state will do its best to address the issues raised in Taylor. Cue the clip from Clueless. Ugh. But if she doesn't do her assignment, how can I do mine? The assignment was on Haiti, and she's talking about some garden party. That is essentially the prosecution here. Absolutely. Fireflies like this is hectic. It's me. I'm the hectic energy today. It's a Friday. It's me. So also this motion is silly. At the outset, and as more fully explained below, the defendant's motion attempts to condense a 33-page opinion into the simple premise that any jury instruction containing the conjunctive and or is facially invalid, which is not what the court said, and entitles Gutierrez to a new trial. Such a proposition is not supported by a careful reading of the facts and law laid out in Taylor, and consequently, defendant's motion should be denied. We didn't even read it that carefully. We read it through on live stream and got midway through it and was like, wait a second, this case law doesn't say what you think it says, boo-boo. Like, reading and interpreting case law is a central feature of being effective. As the court is aware, the defendant made only one objection at trial to the proposed jury instructions in this case, and that objection was to the use of the word negligent rather than reckless. I mean, I would have made that objection too. But do you guys see the issue here? Do you see the issue here? Boo, you didn't object. And if he knew this case was teed up, like, he should have known that this Supreme Court case was coming. Because the second this Supreme Court slip opinion dropped means it didn't even hit publication yet. They knew this was coming, or they should have known this was coming. Because they should have known, most criminal defense attorneys, prosecutors too, keep an eye on the case law that is being taken up by their state Supreme Court in case it's going to impact cases they have coming up. And generally, your office, depending on what office you work for, or your bar associations will be like, hey, these cases might impact the work that you do. So knowing that this is working its way through the system and that this opinion is coming, he knows that there's an and/or instruction in this case. I'm shocked. Unless the prosecution is completely misstating what happened at trial. And if that happens, then I will have all the smoke for them too. But I'm shocked he didn't object to the jury instruction and preserve the objection. Defendant raised no objection to instruction 12A, the alternate theory involuntary manslaughter charge, asserting that the defendant acted without due caution and circumspection, a copy which is attached. Despite not raising an objection to this instruction at trial, or even asserting that it could be confusing to jurors, defendant now asserts the instruction was unlawful based on Taylor footnote 1. In Taylor, the court finds that the defendant in the case objected to the state's proposed instruction at trial, but the court nevertheless accepted the state's proposed instruction, properly preserving the issue for appellate review. That is the key here, properly preserving the issue. Defendant Gutierrez did not object to instruction 12A at trial, nor did she raise any concern regarding the potential juror confusion. So then they break down the case that we've already read together, getting to the heart of what the case meant in Taylor. And what the case meant in Taylor is that if you have 4 different and/ors, so it's thing A and/or thing B and/or thing C and/or thing D, there's the potential that the jury in that case, Taylor, could have found a guilty verdict based on thing A or C, hypothetically, and those things aren't illegal. It would have to be like this and this and this to make it illegal. So in Taylor, the issue was that there was a potential for the jury to find a guilty verdict on behavior that was not illegal. So in that case, there were too many options for the jury to decide, and some of those options were not legal, lawful law bases for a guilty verdict. In Hannah's case, the and/or goes to theory A and/or B. She can be convicted on either A or B. In Taylor, she could not be convicted on, say, A, but she could be convicted on B, C, or D. So if the jury convicted on A, it's not legal. And that's the problem in Taylor. So the state is breaking that down now for the court, saying in Taylor, there were like 4 options, and that's the problem. In the defendant's case, only 2 acts were separated by and/or. The instruction at issue states, quote, Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition and/or. So theory A, she loaded it. And/or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. She can be convicted on A, she can be convicted on B, she can be convicted on both. This simple instruction does not require much effort for the jury to understand. The jury could have found the defendant committed one act or the other, both or neither. The inquiry was straightforward and did not require complicated parsing of syntax, such as requiring the jury to decide between multiple permeations of several acts. And so they go back through the Taylor case, which I think I've summarized pretty well. In defendant's instructions, each act was described fully on its own with no requirement that the jury try to mix and match among several acts. The problem in the underlying Supreme Court case is there were 4 things. Somebody who's better at math than me can tell me how many different options are if there's 4 things, because it can be A and B and C, A and B and C and D, or, B and C, or B and A, or B and D. Like there's like 16 plus probabilities of ways they could mix those things together, and that becomes too much. 24. Marissa's like maybe 24 options. Good. Yes. So there's too many variations. Amora says 36. We're going to go with somewhere between 12 and 100 for the sake of hyperbole. So 24. Look, 24 is the winning number in the chat. Good job, chat. You all are also great at maths, or a solid portion of you are, me not. Lawyer math is like, meh, it's somewhere in there. So the probabilities in the underlying case are the problem. That's not a problem here. So the limit does exist in this case. The prosecution goes on to say the instructions were not confusing to the jury, and the state respectfully requests the court deny the motion, and that is it. So let's look at the defendant's response. This is a first look at the defendant's response. Now I have to find it again, even though I just pulled it up. So this is the defendant's response to the court, to the state's response. Oh, there's the state's response. How did it get in the wrong spot? Oh, I dated it wrong. I have a very specific filing system, and I dated it wrong, and that's why it was in the wrong place. If I think something's on the right and I put it on the left, I'm going to lose it because ADHD is a gift. This is the defense's reply to the state's motion. Let's do that real quick. All right. Defense reply to the state's response to defendant's emergency motion for new trial and release. We have now gone to the Constitution. The United States and New Mexico Constitution through the 14th Amendment mandate unanimous jury verdicts in criminal cases. Issue spotting friends. What is the first issue that you spot? Here's the first issue that I spot. This is a new argument and a reply. You know what you're not allowed to do? You're not allowed to make a new argument and a reply. Lisa, this is probably the truest observation anyone's ever made about me, and says in the chat, EDB appears to have a very fluid relationship with numbers, including dates, times. That unfortunately sometimes also extends to money and distance. My husband, how much does that purse cost? Money. My accountants, what did you spend this on? I don't even remember. It's delightful for me. It's why I need people to wrangle me for both time and distance. So now we're back to the Constitution. Look how delightful this is for us. This is a new argument. As early as 1898, the court said that the defendant enjoys a constitutional right to demand that his liberty should not be taken from him except by a joint action of the court and the unanimous verdict of a jury of 12 persons. If you have to go back to 1898, you're going to lose your motion. Sir. No. Also, this is a new argument that you didn't raise in your other motion. Stop it. He's now arguing unanimity, which was not argued at all. So stop it. This requirement of unanimity was not respected in the involuntary manslaughter instructions given to the jury. Did you object on those grounds? Because the case law in New Mexico, God, I'm getting mad. It's early. The case law in New Mexico clearly says that unanimity on theory is not necessary for the jury to come back on a verdict for involuntary manslaughter. All of it. All of the case law says that when you have two different theories, the jury doesn't have to be unanimous on which theory, as long as they're unanimous that the involuntary manslaughter happened. Some can say she should have checked. Some could say I don't remember what the other theory was on the state because I'm mad about this. But they don't have to be unanimous as to theory. They have to be unanimous as to the charge. And that has been upheld by the Supreme Court in New Mexico. Except now where there are too many possibilities and you can't tell that the jury's unanimous on the charge because one of the theories is not unlawful. You can't convict somebody for an act that is legal. So, in criminal cases, this requirement of unanimity exists to all issues. Okay, so you're arguing that the jury instruction that you didn't object to is unconstitutional. You know what the defense has not addressed? Whether or not they preserved this issue. The defense didn't respond at all to whether or not they made the proper objection to preserve the issue. Like, I know that lawing is hard, like legalese is hard, bro, but your job as a defense attorney is to preserve issues on appeal. Like, that is a primary function of a defense attorney in trial. You have to preserve these issues. And for all of you during trial that was like, is Hannah going to appeal on IAC? I don't know. At this point, my mind might change. I was like, no, I haven't seen anything that's really getting us to IAC. Not preserving necessary objections for appeal starts to shift a little bit. Everyone deserves a good defense. Everyone deserves a good defense attorney. Hannah would have been so much better with a public defender. She would have been so much better off. She would have been so much better off. This case is going to go so different when we see the Baldwin case. And that just frustrates me. Because sometimes you don't know, right? How do you know how to hire a good attorney? How do you know if your attorney is doing a good job if you've never been in this circumstance before? Kara asked, did he suck on purpose? No, I just don't think he does criminal law that much. I really don't. It's just frustrating. If you're now arguing that this jury instruction is fundamentally unconstitutional, you have to object in the moment. So I saw the comment in the chat that hindsight's 100%. Patty, I understand, but this is his job. This is his job. So for us, it's easy to go back and look, but this is his job. So. And he didn't preserve this issue. This requirement of unanimity, she needs a different attorney for appeal. This requirement of unanimity was not respected in the involuntary manslaughter instructions given to the jury. Did you object? Because the case law has allowed for that. There we go. This issue was specifically preserved. The special prosecutor misrepresents to this court the record as to the objections made by Ms. Gutierrez Reed to the jury instructions. I would have led with that. The special prosecutor claimed the only objection made by the defense was as to the use of the word negligence opposed to recklessness. That is false. It took some time for counsel to obtain the trial tapes, and pertinent portions will be lodged as digital exhibits with this court. Ms. Gutierrez Reed objected in detail as follows to the state's involuntary manslaughter instructions. Good. Let's get to the transcript. Play the tape. I might withdraw everything I just said. I might object to all of it. I might withdraw all of it, Mr. Bowles. We might fix things, but you should have led with this and not the Constitution. What are you doing? At 4:57, so what's the response to she wants it all in one? That's the court. Jason Lewis. So, Your Honor, this is the prosecutor, Jason Lewis. So, Your Honor, what we have proposed is to include the count one alternative, and then just a single verdict form. And the reason we're doing that is we're relying on the state versus Goody. He should have the transcript, not the audio, but okay. At 5:24, wait. What happened in between there? Between 4:57 and 5:24 is a big gap in a transcript. And what that says is where alternative theories are put forth under a single charge, jury unanimity is required only as to the verdict, but not to the particular period of guilt or theory. And so this is relying on the Goody case. And so we're permitted to provide two separate instructions, one for negligent use, one for without due caution or circumscription, and then the jury has to unanimously agree under one or both of those theories on the verdict form. At 5:55, Monica Barreras, Your Honor, in the Goody case does not stand for the proposition that the state gets two separate element instructions or two bites at the apple. What they're asking for here is one element instruction and then another one that has two alternative theories in it, and that's not what Goody says. At 6:14, it's quite a gap. It goes on to say what Goody focused on, that's the case site. It focused on the fact that the jury doesn't have to unanimously say when you're dealing with two distinct acts of the same offense. Like it's quoted in the Nicholas case, there were two distinct acts of SA, and those were merely two means of satisfying one element of the crime charged. Then on to 6:49, the jury didn't require unanimity on each act. Well, we know the case law says that. And then down to 7:26, so it doesn't stand for separate instructions. The jury still has to find specific act unanimously. That's not an objection, that's argument. They could find it by way of negligent use, an unlawful act because, like the state proposed, endangered the safety of another by handling or using a firearm in a reckless manner. And then you put in there the alternative way. And what we propose is the alternative way that the state's tried to prove this whole time is that she brought live rounds onto set. And this is not even written in transcript form. It's hurting my brain. And that should be the act by bringing live rounds onto set. Instead, they're trying to say that they're proposing language that judge you're mixing things. One argument is that they have two instructions. The other one, now you're going into the element of it. Why can't you just put one long instruction that says or in the alternative? Jason Lewis said, well, I think, Your Honor, the reason we prefer to do it separately is because these are separate elements. Where is the objection? Defense attorney Monica Barreras is arguing the jury instruction saying, so one thing with their alternative theory is that it looks like in cases involving multiple alternative theories, there needs to be a cautionary instruction about unanimity. Unanimity means the jury has to decide unanimously on the charge. Then they're arguing Dobbs. And then the court says, the defense says, but what we're asking is a cautionary instruction requiring the jury to have a unanimous verdict on a specific willful act that they're finding a verdict on. The judge says, I'm denying your instruction. I can see how the defense interprets that colloquy differently than what the state says. So the state said they didn't object to this. They only objected to negligence and recklessness. I can see where the state narrowly parsing that, which I don't like at all, could perhaps be literally true, but they're asking for this instruction to be read differently, and the court denied that. But they're asking for a separate instruction, so both of them are right and both of them are wrong. The defense isn't objecting to the and or. They're asking for an additional instruction, and that was denied. I told you this record was going to be a disaster on appeal. I didn't think it would be popping up weeks after the conviction, but it's already a disaster, and that's not even a transcript. That's the defense, it seems, going through audio. If this had all been, if the argument over jury instructions had been aired, we would just go back through it together like we did during Depp v. Heard, but the court did not allow things that were outside the presence of the jury to be streamed, so we didn't get to watch these arguments happen. The defense goes and says Gutierrez read specifically preserved unanimity objections where there were multiple alleged acts. I think that's not as specific as it could be, but I also don't think it's they never raised a concern. So if I were the court, I wouldn't just bump them on you didn't preserve it. I would actually address the issue and say, assuming it's preserved, because it's sloppy, but we don't have the full transcript of information, and they were arguing about it. So I wouldn't just yeet it on you didn't preserve it. I would address the issue, and we'll see what the court does in just a minute. They say the special prosecutor doubled down on the error and specifically argued in closing that the jury could split their findings between the various acts. 6 of you could find this act and 6 the other. They didn't raise that in their original motion. This is the very premise and principle of the error addressed by the Supreme Court in Taylor. The special prosecutor attempts to distinguish Taylor by saying that there were 4 alternative clauses in that case, and there are only 2 here, so that case was less confusing. In essence, this isn't the holding and principle in Taylor. It's broader than the number of clauses. I don't agree with their interpretation of Taylor, but all of this should have been, look at this, there's argument. All of this should have been in their original motion. Accordingly, Justice Vigil announced broader principles and premise in Taylor, that was all dicta, regarding the confusing use of and or as a connector for multiple acts. That was not the holding. I feel like I'm in law school. And the need to ensure that the jury is unanimous as to the particular act alleged to have been committed. I realize I'm just yelling dicta at you guys and not pausing to explain. Here's the thing. Some of the things that the judge said were not the holding that is legally actionable. Some of them, as we explained dicta in other content, some of them are like the lore. They're not canon lore. Dicta is outside. It is explanation, exposition. It is not the holding. It is not what other courts are held to. Other courts are held to what is canon in a thing, the holding. Dicta is outside of the canon. So it's your offshoots, right? And it's like, well, yeah, that's in the universe, but it's not canon. We're not held to it. I'm sure all of you can come up with better analogies within different cinematic or comic or anime universes for what is canon and what is not canon. Dicta is the conversation that is outside canon. It's the commentary. So the canon, you're like, dicta is fanfic. Not quite, but dicta is the conversation around it. It's not the actual holding. Other courts have to adhere, if it's controlling authority, to the holding, but they don't have to adhere to the dicta. Yes, EB in the chat said dicta is the chat. Yes, it is the conversation around it. Sparkle noise, dicta. I love dicta. Damn it. That. Here's what I meant by that. I love when the courts signal what they're thinking outside of their holding. And in the dicta of cases, you can see where the courts are leaning on a particular issue. And then if another case comes up that kind of falls within what they're talking about, how they're going to rule on that case. it gives you kind of some foreshadowing of what the court is thinking, where the holding is very, very, very narrow to the exact and specific case. And they keep rulings very narrow because the way that courts build their, jurisprudence is through these holdings on specific topics, and those build onto each other to build the jurisprudence of interpreting the law of the land. It's lots and lots and lots of thinking and conversation of what the court means. So it is really that foreshadowing. So some of this is the foreshadowing, not the holding, so the court's not be held to it. The defense, I saw the word smorgasbord, so we're going to have to finish this. The jury instructions here, the defense says, invited the jury to come to a non-unanimous verdict, picking and choosing from a smorgasbord of different and varied acts to achieve a conviction. It's my understanding that under New Mexico law, they do not have to be unanimous on theory. This is precisely what the special prosecutor invited the jury to do in her closing arguments. This is precisely what cannot be done in our criminal justice system, where a person's liberty is at stake, as the Supreme Court held in Taylor. So these are the arguments over Taylor, the Supreme Court of New Mexico decision. The state is arguing that the defense has misinterpreted this case law. The defense is arguing in their reply, which is not where you bring new arguments, but whatevs. The defense is arguing that the state is being disingenuous with that the state misstated to the court that the defense did not preserve this issue on appeal, and that the jury instruction itself is unconstitutional, which should have been brought in the earlier motion, and that, in fact, this case law stands for a broader proposition than what the state is trying to say. The state is like, this holding is very narrow. The defense is like, this holding is much broader. The court's going to have to decide that, and then this will probably go up on appeal. Should we go see what happens in court today? Shall we go to court? I think we should go to court. Hold on. Let me make sure that the volume is good. And we're going to go to court from this morning. I'm going to bump up the potato. This is Zoom court. So give me 1 second. Hold on. I need to add more sounds to the soundboard, but come to order. All rise, ladies and gentlemen and law nerds of the chat. The Honorable EDB Streaming Court is now in session. Let's go. Let's go. It would have been better if I had timed that so that my screen share was ready. I could probably do that again in the future. We'll have plenty more court days to try that out better. Let's go to court, shall we? Shall we get into court? Shall court go? Go, court, go. There we go. Me. Go, court, go. Let's go. And then it. Cheers to the spinning wheel. All right. Hannah is, of course, coming in from custody. There's no audio yet because she is in custody from the Santa Fe Adult Detention Facility, bopping around. When all the lawyers come on screen, we will have audio from the judge.
All right. Good morning. The matter I'm calling is D-101-CR-2023-40, State of New Mexico versus Hannah Gutierrez. Parties state their name.
Carrie Morrissey on behalf of the state
I'm going to move
of New Mexico. Good
Hold on. I'm going to move the
morning.
I keep trying to grab the closed caption and move them, and I can't. So I'm going to have to move me because the closed caption are on the original video, so I cannot move the closed caption elsewhere. So let me move me real quick. There we go. Because normally I would put that closed caption up above their heads, but this is on the original video, not on my video.
Good morning, Your Honor. Jason Bowles from Ms. Gutierrez-Reed.
Good morning.
And good morning, Your Honor. Monica Barreras, also present for Ms. Gutierrez-Reed, who appears in custody. Mr. Bowles will be handling the hearing this morning.
All right. Go ahead.
Your Honor, thank you. Judge, I wanted to touch on some principles in the Taylor opinion this morning and also the Godoy case. in light of the jury instructions provided at this trial.
I mean, I've been pronouncing that case Goody, not Godoy. I have no idea which one is correct. We're going to just go with it. He always looks like he has a steeple coming out of his head, Chad. I am aware every time he streams from his office, it looks like he has a steeple coming out of his head. I don't know.
Judge, at the time of trial, none of us had the benefit of the Taylor opinion, which, as this court knows, came out after the jury verdict. So I first want to talk about the jury instructions given, which this court is aware. There was a jury instruction given in 12A that gave the jury two alternatives connected by an and/or connector. And those two alternatives were the alternative theories for involuntary manslaughter that the state had advanced at trial. So the instructions provided that the jury could find Ms. Gutierrez-Reed guilty under either alternative theory connected by an and/or. Following the jury verdict, the Taylor opinion came out, and there's an important several principles in the Taylor opinion, and we cited that in the reply. The first one I want to read is from paragraph 9 of that opinion, which states that specifically defendants argue that the instructions listing the elements of essential conduct with an and/or conjunction provided for alternative ways for the jury to find the defendants committed child abuse without requiring the jury to unanimously agree on any of those alternatives. Applying a de novo standard of review, we agree with defendants. And Judge, then I want to go down to paragraph 16, which I've excerpted, where the court indicates that this.
So yes, he is just reiterating the arguments he made, not in his motion, but the arguments he made in his reply. I think these should have been made in his motion. Jessica, we will break it down a little bit more, but the heart of this argument is that there was a Supreme Court ruling that came down right after this trial. The defense is arguing that the Supreme Court ruling makes the jury instructions used at this trial invalid, and that therefore grants Hannah Gutierrez automatically a new trial. That is the defense's argument. The state's argument is that this ruling does not apply to Hannah's case, that they are distinguishable, and therefore a new trial should not be granted. So Taylor is the underlying case. Lawyers work on statutes and case law primarily. The legislature writes the statutes, and oftentimes the legislature is not all lawyers. I mean, there are some lawyers, but the legislature writes the statutes, and they lay out ways to do things in the law and in regulations. The Supreme Court generally oversees things like the model jury instructions or the model uniform jury instructions, the MUJIs or the UGs or whatever you want to call them. And those jury instructions also get interpreted, because you will get a jury instruction and then you'll get a wonky result. And they went, well, is this jury instruction the cause of the wonky result? Did that violate the defendant's right for due process or other rights because of the way this jury instruction was written? So does this need to be thrown out? Do we need to do something different, new, or better? And then case law will fight about that question as things get appealed. And then case law will change things and say, yeah, that jury instruction's bad. Throw that out, new jury instruction, you get a new trial. And so this is the argument here, is that this jury instruction, and this is a jury instruction when we read through the Taylor case that has had issues in the past and has been fine-tuned, because the courts will always make like the small change and then see. So it is very much a shifting process. This is why law takes forever to change, because the jury instruction will be written, they'll be approved, a trial will happen, it will get appealed, the appellate court will look at it and go yes or no, then it will go up to the Supreme Court, the Supreme Court will be like, we're not doing this, then it will go back down to the trial court for a new trial, and then things will be changed, and then they'll go back up through the appellate court, and that takes years to go through the court system. So that's where we're here doing this today. All right, let's keep going. So Alice Omniac said, question, can it be retroactive? It depends on what the case law is. Yes, there are times when a new Supreme Court ruling will come down that will change things for defendants who have been convicted, but not always. So yes, sometimes it depends, and it depends is where lawyers make all their money, because it's tremendously nuanced and sometimes quite complicated. Sometimes it's very clear. Sometimes it's not. So that's where the law changes, and you will see appeals later saying this law changed after I was convicted, and the law, if the law especially finds something unconstitutional and someone was convicted under a law that's now determined to be unconstitutional, then that absolutely can go back retroactively.
Violated our teaching in the consul opinion, 2014 NMSC 030, that when two or more different or inconsistent acts or courses of conduct are advanced by the state as alternative theories as to how a child's injuries occurred, then the jury must make an informed and unanimous decision guided by separate instructions as to the culpable act the defendant committed and for which he is.
Remember, what we just heard from the kind of rough audio recording transcript that the defense made in their reply was that the state was arguing for separate instructions and they said no.
Is being punished. And so, Your Honor, our argument under that principle is that we had two different acts in this case. The first act being that she loaded a live round into a gun that was supposed to have inert ammunition. And the second act was that she did not allegedly perform an adequate safety inspection of that firearm.
Two theories.
Based on those two paragraphs in Taylor, there should have been separate instructions, and there should have been the requirement that the jury unanimously find which act it was, which theory it was.
We just read the transcript where you objected to the separate instructions. You objected to the separate instructions. The court said the prosecution said we can do separate instructions. We just read, you've just changed your argument from your reply. I'm glad we did the replies first. That's why we did them first. Because in the reply, you guys were arguing they shouldn't be separate instructions, that the prosecution doesn't get two bites at the apple, that there should just be a unanimity instructions. Sir, that's not what you argued in your motion.
Was that they said she committed. The problem with the verdict under Taylor that we have at this point is we don't know which act the jury may have found unanimously or whether it was unanimous. And the other problem is that the special prosecutor specifically argued in closing that the jurors are able to find 6 can find one act and 6 can find another. So there was no requirement that there be unanimity. That is precisely what Taylor is saying in paragraphs 9 and 16, that there has to be a finding of unanimity on that particular theory. Now, in Taylor, there were 4 alternatives. And so the court discussed there were 4 alternatives, and it was more confusing with the use of and/or when there were more than 2. That court did involve 4 alternatives. 2 of those alternatives involved CYFD policies, which they said could not be a legally adequate basis to convict. However, that was not the entire holding Justice Vigil announced, which was that anytime, and they criticized the use of and/or and said courts should consider abandoning the use of that.
That part was dicta. The court was very critical of the use of and/or and said, I don't see how this can ever be valid, and courts should consider abandoning it. That's not their holding, though. This is like deep law school shit, but that's not their holding. That's not what's canon. That's not what is part of the jurisprudence. It was the court advising, hey, I think when you guys rewrite these jury instructions, you need to get rid of this and/or language. It's very, very confusing, and it can lead to bad results. So let's just make everything as clear as possible. I agree. Jury instructions should be as clear as possible, but that's not the holding. That's the dicta. So
that instruction altogether. What they said is anytime you have 2 or more, going back to consul, that there should be separate instructions to guide the jury to a unanimous decision. Now, that is how Justice Vigil announced Taylor in the Supreme Court, the Godoy opinion was not overruled until
Also, yes, chat, I very much want to send him a riser for his laptop so that he can be kind of at eye level with his computer. Just a little. The way I'm tempted to start a business and just start calling lawyers that do these Zoom calls and be like, can you please just let me help so that it's just more visually pleasing for all of us? We can help. Just get just a riser. I'm gonna put it in my Amazon shop. Just a riser to pull pull it up, or just a separate webcam that you could just. There's options here, but there's no glare on his glasses, which is lovely.
Taylor. Now, the court did discuss Godoy being a fundamental error review because in that case, there was not a specific preservation. The state in their response indicated that our only objection at trial to the instructions was the use of the word reckless as opposed to negligent. But as we cited in our reply, and we had to get the trial tapes to delineate that, that was not our only objection. In fact, Ms. Barreras specifically made the unanimity objection, and it's laid out in our reply.
Which is
good.
There's a nuance different there about, and if I were the court, I would let it go on this issue and just rule on this issue. But I think there's some room to argue here, and it does for all of you saying it does look like it does look like a nostril cam all the time.
Godoy involved a case where there were trafficking charge and a step-down possession charge for cocaine. So there in Godoy, the court said on fundamental error review, we don't find an issue with the jury not being given separate instructions because there's a step-down instruction, and we had one in this case.
The step-down is a lesser included crime, meaning that the jury can find like he's using cocaine, or the case has, damn it, Emily, that doesn't sound right on the internet. He's using the example of the cocaine charge in the underlying case. And so the step down example would be if you have a possession with intent to distribute or sell, the step down would be just a simple possession. So it's the example that on the involuntary manslaughter, you could have the involuntary manslaughter charge or the step down or lesser included charge that would be the negligent use of the firearm. So Lyndon in the chat says, he's a pusher, Your Honor. Referring back, of course, to Mean Girls.
Instructions very detailed and explains to the jury, if you don't find the lead charge, then you go to the next step down. So in that case, on a fundamental error review, the court said the jury didn't need any additional guidance because they must have found cocaine. So they found the possession charge in Godoy, but they didn't find the trafficking. But they did have language in that case where there are different acts, there are different ways in which crime can be committed. That's when, Your Honor, we are in this case, which Taylor talked about, when there's separate theories and those have to be unanimous. So that's why I submit to the court that Godoy is not applicable, that the principle of Taylor is applicable, that we need a unanimous verdict on the specific act. And so, Judge, I submit.
It's interesting because they're arguing you need a unanimous verdict on the specific act, whether, and I have a lot of content breaking down the involuntary manslaughter. There are two theories. One being that she did something that was unlawful, and that was then somebody got killed, and that's the basis. The other one was she was doing something that was lawful, but she did it in a way that was reckless/negligent, and that recklessness led to somebody's death. So those are two theories. He's arguing that they are not theories, and that is a nuanced distinction that actually does have a difference. We'll see what happens when we get to the prosecution arguing. But on theory, there doesn't have to be unanimity. You just have to be unanimous that the involuntary manslaughter was committed, and that is very clear within the involuntary manslaughter.
Because of that, and none of us had the Taylor opinion at the time, but now that we do, I think this is a reason that Ms. Gutierrez Reed should be entitled to a new trial with instructions that are different, that follow Taylor and they track Taylor's language, requiring a unanimous verdict
Remember
on
when
a
the-
specific act.
Remember when they
alleged-
asked for two
that she
different
alleged to
instructions
have
and you said
committed.
no? Remember that? That's weird.
Thank you, Ms. Morrissey.
Your Honor, in response, first I want to
Also, her Zoom setup isn't any better. Like the amount of headroom is killing me, but there is a blur, which I appreciate. But the streamer in me wants to help.
point out that the defense's initial motion was 2 pages long.
Though her lighting is good.
So we did our very best to respond and kind of try to anticipate what we would.
For those of you saying, Carrie, in response, heck no, I'm waiting for her to be like, in response, first, how dare you? You brought in all of your new arguments in your reply. And here's why it's such a problem. Because the way that motions work is you generally don't get a sir reply. So the defense makes a motion, the state responds, and then the defense can reply only to what the state said in response. You can't bring new arguments because then they don't get to respond to it. So bringing all your new arguments at the end is very frustrating. But Carrie should know this because she did it the entire trial in her redirect examinations. It's the same process. You do your direct examination of a witness, then they get to cross-examine, then you get to redirect just on what was cross-examined. And this was her game the entire trial, where she would leave half of her direct examination to her redirect. So he's playing her game 100% in this. And she's like, but Your Honor, he's exactly playing her game from trial. But there is a procedure to this. You make your arguments, the other side responds, and then you get to reply to that, and that is it.
Be seeing in their reply. If certainly I would invite the court, if the court is remotely inclined to grant this, to request additional briefing.
Oh, Your Honor, you're not actually considering this, are you? But if you are, we need to go more in depth than they do.
Because to a certain degree, I feel like we got a little bit cheated out of an opportunity to fully respond, because the initial motion was so threadbare. I've never seen a motion for a new trial that was 2 pages.
Same. I mean, to be fair,
so
same.
having said that, in response to Mr. Bowles' argument, I want to point the court to, excuse me, I have a little bit of a cold. I want to point the court to Taylor paragraph 14, where the court in Taylor indicates.
I feel like I'm being stared at. Ma'am, I'm sorry, but me on a Zoom call. I'm just like trying to, oh, Zoom court.
I'm just going to read it for the record, if that's okay. Using and or to separate 2 terms such as A and or B invites the reader to choose only A, only B, or both A and B. Thus, the reader is presented with only 3 options when and or is used to separate 2 terms. That's exactly what happened in Ms. Gutierrez's case. Is exactly what Taylor described in that very short paragraph. Taylor then goes on to discuss the very complicated scenario that happened in the Taylor case in terms of the jury instructions. So the court goes on and says, however, opposed to and or adding an additional proposition C can leave the reader guessing whether and or is intended to be placed between all propositions or only some of the propositions. And that was really the problem in Taylor. The problem in Taylor was they went beyond and or separating 2 alternatives, and they had 4 alternatives. And in addition to that, the acts that were outlined in those alternatives were just legally insufficient to support a conviction.
That's the key.
You know, for example, if a daycare worker, a childcare worker doesn't follow CYFD policies or training, that in and of itself is not enough to
Sustain a conviction.
satisfy the elements of the offense.
And the Taylor case, I did break down. The Taylor case is a different scenario, and the Taylor case is child care workers that left children in a car. I don't think they're going to get more into the details of that, but some of the acts to show negligence were that the workers violated policy, but violating policy wasn't in itself enough to get to the to get to a conviction, because those acts weren't enough. So that's a completely different scenario than what we have here. So she's distinguishing the Taylor Supreme Court case and the actions in those cases and the jury instructions in those cases, because some of the acts in and of themselves were not lawfully lawful to find a conviction, which is what she's saying. Different than the Hannah Gutierrez case, where the jury can convict on A or B or both A and B. Hopefully that helps make it make sense.
Of that child abuse charge. So we certainly don't have that element in this case. In this case, we had two.
That was my mouse. I'm sorry. I didn't mean to leave my mouse on her face and make it look like that was me.
Alternatives in 12A
Apologies, Ms.
for
Morrissey.
the jury to consider, both of which were absolutely sufficient for involuntary manslaughter.
True.
It's my recollection that in closing, what I invited the jury to do, and this is a little bit different than what Mr. Bowles is suggesting to the court, what I explained—
Wait, ma'am, why didn't you just go back and watch it? Like, I don't know. If it was me, I might go back and watch my closing, because if somebody asked me to remember the things I say on stream, I don't always remember exactly what I say. And that is particularly true in trial, where you're like, I don't think that's what I said. That's not what I remember what I said. But when you're processing information in the moment and formulating arguments and moving forward, sometimes you don't remember exactly. So I would have gone back and watched it. I mean, it's on the internet. Why not?
to the court is you've got 12 and 12A. And between instruction 12 and 12A, there is unanimity is not required. I don't believe that I suggested to the jury that the options within 12A did not require unanimity. That's my recollection of my closing. I can see Mr. Bowles shaking his head. We haven't had the reason that when Mr. Lewis filed his response and he indicated that the defense didn't object to this was because he didn't have the benefit of the audio and the transcript. And that's one of my concerns, is the defendant had the benefit of the audio and the transcript when they filed their initial 2-page motion, but they certainly haven't shared it with us.
You could have requested it though, couldn't you?
I'm happy to provide additional briefing on this if the court thinks that that's necessary.
Can we not kick it down the road more? No.
She
did say she has a cold.
The unanimity issue and the Godoy case, Taylor actually, as Mr. Bowles pointed out, upholds Godoy and the argument that, or the principle that unanimity is not required when there are two alternatives. And in this case, we had two alternatives, that being 12 and 12A. So while I appreciate the fact that the Taylor case may give guidance in the future to how to properly construct jury instructions that have and/or separators, the Taylor case actually has language that specifically supports what we did in this trial, there only being two options in 12A separated by and/or. So I'm a little confused about what the defense thinks the strength of their argument is, because when you read paragraph 14,
Well, the defense thinks the strength of their argument is obviously she gets a new trial. They said it in their first motion. They didn't even argue the law. They're like, obviously we get a new trial. There is no other conclusion. That's what they think the strength of their argument
Taylor
is.
actually is supportive of the way that we did it in Ms. Gutierrez's case. So for those reasons, we would object and we would ask the court to deny defendant's motion. And if the court has any specific questions for me or any concerns, I'm happy to address those.
Thank you. Reply.
Yes, Judge.
Please don't ask for new briefing, Your Honor. I feel like the judge already knows what she's going to do in this.
First, Judge, the opinion in Taylor does say in paragraph 9 and 16, it doesn't limit that language to 4 propositions. The specific language in 9 and 16 is the consul case when 2 or more different or inconsistent acts. That's specifically stated. And that's what Justice Vigil is saying in Taylor, is that the unanimity principle is the problem. The unanimity principle as to which different act. So it doesn't matter if it's 4 or 6 or 8 or 2.
I don't
It's
agree.
the idea that under our Constitution, there has to be a unanimous verdict as to the specific act. That is the issue that Taylor is stating. Now, I agree that
I just don't agree. I think that is a separate argument, that the court was indicating that the jury instructions could allow for the possibility that a jury would not be unanimous on a theory where the act itself is not illegal. But I think it's more nuanced and less broad than what he's arguing, because so much of the jurisprudence in New Mexico says that you can have the jury come to a unanimous verdict and not be unanimous on the theory.
Ms. Morrissey is correct in 14 that they talk about 2 or more, A or B and C. Now, the reason why they were going into that is because they were emphasizing that here we not only have 2, we have 4, which made it more confusing. So it was more confusing in Taylor under those specific alternatives, but it didn't change the principle they're announcing, which is that when 2 or more, it has to be unanimous and it has to be separated. And Ms. Morrissey, it is hard to remember exact language, but she specifically said in closing, 6 of you can find one act and 6 in another, and we have those tapes. All of us, can request those.
Can we get the timestamp? I honestly feel like the lawyers have maybe they're not even remembering that this is all on YouTube. Like, it just feels like they're not even thinking about it, because they're like, we can get the tapes. They mean from the court reporter. They can get the transcripts from the court reporter, but they could have easily just gone and watched them back. I mean, okay. I mean, yes, the official record needs to have them from the court reporter, but they easily could have reviewed it.
Tapes, so we can get that transcribed if the court wants that, and we can make that part of the record. Okay. But the problem is this jury was invited to find a non-unanimous act and just conglomerate them. That's the problem that Taylor announced.
He's doing a good job of trying to make fetch happen.
All right. Thank you, counsel. So I do agree that your motion was very sparse, and it just focused, your motion for a new trial was very sparse, and it just focused on the and/or, and because we had a jury instruction in and/or, Ms. Gutierrez was entitled to a new trial.
That's exactly what he said.
It wasn't until your reply where you fleshed out.
Are you going to ask for more briefing? I don't want to do it again.
Issues that you had already stated regarding the unanimity aspect of things. I have read Taylor, I've read Gaudet, I've read Consul, I've read very many cases. I'm very aware of what occurred at trial. I'm very aware of the discussions that occurred on regarding the jury instructions. And I am denying your motion, Mr. Bowles, because I do not think that Taylor requires a new trial. In this case, I think that
this is specifically going to the fact that she's not kicking the can down the road and making a ruling. Thanks, Your Honor. She's just like, no, I am well aware. We're done. I'm going to let her make the rest of her record on why she's denying this motion for new trial. Also, we have a new blue jay at the bird feeder today. That's exciting stuff over here at the Baker house.
Taylor, I've read Good Day. I've read Consul. I've read very many cases. I'm very aware of what occurred at trial. I'm very aware of the discussions that occurred on regarding the jury instructions. And I am denying your motion, Mr. Bowles, because I do not think that Taylor requires a new trial.
I agree.
In this case, I think that the issues in this case, the jury instruction in this case, are distinguishable
I
from
agree.
what happened in Taylor. I'm going to provide a written order outlining my reasons so that there's no misstatements of what I'm to make an oral determination. So I'm going to do a written order, but I wanted to let you know that I'm denying your motion for a new trial. I will put it in an order. You should get that on Monday. And we are staying the course on the sentencing.
Okay. Period.
Yes, Your Honor, and I had one additional request to the court in my motion, which was, and if the court were to address this at sentencing or to address it now, which was to consider release of Ms. Gutierrez-Reed pending an appeal
I don't think
and
you
a
want
writ
that.
we would take
I don't
for
think you want
guidance
that.
from the appeals court and Supreme Court. And I just wanted to
I don't think you want that. I don't think she's going to get released, but I don't think you want that because I think there's a very real possibility that Hannah could get sentenced to a sentence that will be tantamount to time served. I don't think you want her to come out and then have to go back in at sentencing. Sentencing is what, April 15th? So I don't think you want her to be released until sentencing and get out and have to go back in and process all the way back in. I do think there is a very real possibility that whatever her sentence is, custody-wise, I think it'll be a longer probationary sentence, but custody-wise, I think the amount of time she has served might mean that when she is sentenced, she will not be held very much longer. I don't think she needs to be out pending appeal because I really think she's going to get mostly a time served sentence or a sentence. If she gets 6 months, she might be in another few weeks. I don't think you want that. I think it's more of a pain in the ass for your client.
add to that. She didn't have any violations pending trial. She takes care of her father, who has been diagnosed with leukemia.
Well, that's
She
unfortunate.
works and she has been in counseling. So she hasn't done anything wrong. She's not a danger.
I think he's referring to because she was out of custody this entire time from the incident to the trial. I think that he's saying she hasn't done anything wrong in her pre-trial release, but she has been convicted, but I do think he is referring to during her release before trial, she didn't violate the terms of her release. I think that's what he means. It just post-conviction sounds really weird to say it that way, but I think he's referring to she never violated her terms.
Didn't have any violations.
I think that's what he
pending
means. I
trial.
backed it up a
She
little.
takes care of her father, who has been diagnosed with leukemia. She works and she has been in counseling. So she hasn't done anything wrong. She's not a danger or a flight risk. And I think there's an appellate issue that we have stated that we will raise and a potential Supreme Court writ. And I just think it's unfair if there's any chance of the Court of Appeals or Supreme Court seeing it differently, that she served her whole sentence on the chance that it could be reversed. So I'm just asking the court to consider that based on all.
Well, you don't know what her sentence is yet, though. Like, you don't know what her sentence is yet. So there's no argument that she's going to serve her whole sentence while waiting for appeal because you don't know what her sentence is. This is the situation that happened with Jussie Smollett, right? He got sentenced to a fairly short custody sentence, and they're like, hey, we believe there's this real issue on appeal. He should be allowed out pending appeal, and he was allowed out pending appeal because he would have realistically served his entire sentence before the appeal even got through the process. Different than like the Chrisleys, who have said, hey, we should be out pending appeal. And the court's like, you've been sentenced to like 12 years. So no, that's not what we're going to do. But you don't know the sentence yet, sir. So you're going to have to wait like 2 weeks.
Those grounds and the fact that she hasn't had any violations.
Bring this argument
Ms.
later.
Marcy.
Well, we do oppose.
I'm waiting for somebody to be like, life isn't fair. Like, I don't know. Like Abby Lee Miller or something. Just like, what do you expect? It's unfair is generally not legal grounds. Inequitable sometimes is the legal way to say unfair. Unjust sometimes works, but just unfair tends to not work well in court.
Ms. Gutierrez's release. If this were like a motion to review conditions of release, I certainly would have been able to address my concerns with regard to Ms. Gutierrez and potential release. I'm opposed to it. Does the court want me to go into, I mean, I actually asked Mr. Bowles for proof of Ms. Gutierrez's employment history during the time that the case was pending, and any counseling and treatment that she has completed or participated in. To date, I don't believe he's provided me anything. While Mr. Bowles wants to make these statements to the court this morning, these are things that I requested from Mr. Bowles, I think, over a week ago. I did it almost immediately after the trial so that I could be thoughtful
in your sentencing memo,
in terms of coming up with a sentencing recommendation at the sentencing on April 15th, and I've received absolutely nothing. In terms of Ms. Gutierrez's full compliance with her conditions of release, I think there are some arguments to be made there if the court wants me to make them now.
We do. Just because we're curious, we do. We just like we would like to know all of it. Just like let's chat. Let's chat.
The jury found Ms. Gutierrez-Reed guilty. She is.
Excuse me, Mr. Bowles. When you said she didn't do anything wrong, the court would like to redirect that sentiment and remind you that she has been convicted. I truly do think what he meant was in pre-trial release, that she had no violations, she had no issues, but that's not how it came across to the court based on this court's response.
The jury found Ms. Gutierrez-Reed guilty. She is incarcerated at this point. She's facing incarceration time. Keep in mind, there was a death that the jury determined was caused by her. So I am not releasing her. All right. Thank you. We are in recess.
And Judge.
Sir, she said we're in recess. Those are the magic we're done words. Are you ever waiting for the court in this case? This would never happen, but are you waiting for the court in this case to be like, I said cut, motherfucker? For those of you that didn't watch the trial, that is a callback to the trial. Mr. Bowles really doesn't want them to be in recess. Yep, and they are. We're in recess, and he's like, Your Honor? She's like, nope. She noped right out of that Google Meets immediately. And with that, the court is done. A fairly brief hearing, though needed, in the Hannah Gutierrez read. Let's go ahead and summarize what happened. Hannah Gutierrez was in court via Google Meets today with her attorneys and the prosecutor and the court. The defense, of course, arguing for a new trial and for release. The court denied both of those requests and denied the request for further briefing, denied the motion for new trial, and agreed with the interpretation of the case that was underlying this very threadbare defense motion that the prosecution took, and I interpreted it that way as well, as did I think everybody but the defense. Will the defense appeal this post-sentence? Probably. Will we see what Hannah Gutierrez's sentence will be shortly? Yes. Her sentencing date is still set for April 15th. That will be an in-person in-court hearing. I anticipate that that will be streamed and we will see her sentence that day. She is facing a maximum of 18 months in prison. This is also a case where there is no floor to her sentence. So there's no mandatory minimum prison sentence. So could she get probation and time served for the time she's been in custody since trial? Yes. Could she get a amount of time anywhere between 1 month and 18? Yes. Could she just get probation? Yes. I mean, they would give her time served as well, but yes. So this is a case where it is not a foregone conclusion that she will spend a substantial amount of time in custody. It is up to the judge. And we heard a little bit at the end of the hearing that the prosecution has asked the defense for certain information to inform their sentencing recommendation. But we will see all of that at sentencing. And the judge reminded the defense at the end of the hearing that this is a case involving a death, that Hannah Gutierrez is facing prison time, and that she was convicted by a jury. We will see what happens in this case at sentencing. Let's get to your questions. Hello, chat. We're just going to answer questions and have a little bit more of a chitty chat. We're not going to get into any additional topics today. We have lots of topics to cover next week, as you can imagine. Lots to cover in the podcast. I've been prepping the podcast out for the next couple of weeks. We have a lot to get into before the Karen Read trial starts. I do anticipate that jury selection will start on time in that trial out of Massachusetts. We have not traveled to Massachusetts yet. I do anticipate that will start on time. The appeals in the Karen, I can already see, like I can already see how many appeals there are going to be in that case after trial. But with the Karen Read case, it looks like it's going to be about 5 weeks. It is a very odd homicide case. There is it's different than a lot of the cases that we've covered. Except maybe Murdaugh. There was some stuff in Murdaugh that was like, it'll be interesting to see how we get there. There's a lot more there in Read. There's evidence that still hasn't been turned over yet. There's DNA reports that still haven't been turned over yet. Late yesterday, the court denied a motion to remove the prosecutor from that case. And the court has said for the last few months, this is going to trial on April 16th. So after the jury selection process, we will join that case at opening statements. I'm going to do a shorter podcast on the overview of the case. I'm not doing a deep dive on the case because there is so much information to the side of this case that I am not going to get into. There's an entire circus going on with this case. But the quick overview with Karen Read is she is accused of hitting her boyfriend, who is a Massachusetts law enforcement officer, with a car and leaving him, and he died because of that. Her argument is that this is a complete cover-up. He was at a party with other law enforcement officers. Something else happened, and they're pinning it on her. There is quite a lot of controversy. There's a lot of, it seems, conflicting facts in this case. There is stuff that was seemingly suspiciously missing. There is a lot of law enforcement potential conflicts of interest in who's investigating the case versus who was at the party. There's a very odd case here. I'm not diving into all of it. We're going to see how this plays out as a jury. So it's going to be strange. This one is going to be weird. The autopsy doesn't seem to match up with the prosecution's theory of the manner of death. The prosecution may be under federal investigation for how they're handling this case. Like, there's stuff in this case. So we're going to watch it together as a jury. I do not want to come in with any preformed opinions on what's going on. My preformed opinion is like, oh, this seems interesting and this seems odd. I have a ton of questions. So we're going to see how the trial answer those questions or doesn't. We're going to watch it unfold together as a jury. So if you're coming into this case going, I don't know what's going on, that's okay. The opening statements should tell us what's going on. My intention with this case as to everything that we know from all of the motions is that I will go back and cover that after we go through the trial, to be like, the trial said this, and this is the stuff we know outside of the trial, the way I did with Depp v. Heard. I want to go into it with not a ton of external knowledge, because I'm very interested to see how the attorneys prove their case and ask the questions along the way with you. I don't want to go in thinking one way or the other. So that is set to be about a 5-week trial. So we're going to get into live trial coverage. I am not covering Chad Daybell. That case is starting, I believe, on Monday. I'm not going to be covering it. I know a lot of you will want to watch it. So I understand. I'm not covering it. And I'm very interested in all of the alleged cover up, the alleged missing evidence. I'm very interested in all of that and what's going on in Karen Read. The Chad Daybell case is very, very sad, very, very difficult. And I really don't love covering child victim cases, but I know if you guys want to watch it, please feel free. What else is going on? I will be covering, there is so much going on with P. Diddy. I will be covering it on a podcast, because I'm going to bring in, there's just a new amended civil case that was just filed yesterday. There's other lawsuits that are now being filed. So we're going to pull all that together and do an overview on the podcast, but there is no indictment yet. So it is really early to cover it. What else do I see coming up? There's a bunch of hearings that are coming up in the beginning of April, and we're going to try to get to them all. Alec Murdaugh looks like he's still going to be sentenced on April 1st. There are new responses and a court order as to that we're going to cover early next week. Maybe on Monday, if I can get the podcast done, maybe on Monday. The mods are like, what do you mean maybe on Monday? We'll see if we have time. Otherwise, Murdaugh will have to be Tuesday. We'll just see what happens. There is a court hearing for the TikTok defamation case on April 16th. So I will probably stream, that's the day jury selection is supposed to start in Karen Read. I will stream after that court hearing to go over the documents and tell you what happens at that hearing. We have a lot that we need to cover in May, and I need to backfill what we haven't caught up yet on to then. So when I'm looking at how much we have coming up, it's substantial. And we will get to things as we can. But Emily still needs to sleep. The team still needs to sleep, and I can't stream every day and then go into a 5-week trial. I will fall over. We are working on adding a docket to the app. So don't worry, we are working on that. But it is just a lot. Like, it is just a lot. So Lizzie said the TikTok case is still going. How has the judge let it go this far? Because there's not been a point to end it yet legally. So we'll do that for sure. Let's see. So that's kind of what we've got going on. Let's get to some of your Q&A. Cindy Y, thank you for the gifted memberships. Fiona W, thank you for the gifted memberships. Michelle, thank you so much. It's good to see everybody's member chats. I'm going to pull these up until we get to questions just to say thank you. Mama Wolf, thank you for the memberships. Lisa, 28 months. Good morning from sunny, carefree Arizona. Love a morning with EDB. Yeah, Arizona is one of those states where we haven't had a bunch of cases coming from. Utah is quaking because we spend so much time there. Utah's like, I can't even. Carrie, thank you for the gift of memberships. You guys, I'm still reeling from Corey Richens, all the Corey Richens information yesterday. Like, my brain still hasn't caught up to all the Corey Richens madness that's happening. I'm just like, what? And here's where I'm torn. What are we going to do when the Corey Richens preliminary hearing overlaps with the trial in Massachusetts? Like, I don't know what I'm going to do. Like, we can't stream both. Like, these are problems that the team is going to have to figure out, because The Corey Richards prelim, I'm so waiting for, and it's probably going to be a couple days, but it looks timing wise like the Corey Richards prelim is going to happen while the Karen Reed trial is going on, and we're going to have to figure out how we're doing it because I have to know. Like I can't not. Danny, it's good to see you in the chat. Corey, it's all the things that makes a sometimes truth is stranger than fiction criminal case. It is all of it. And I've seen from the comments on the videos that there are members of the community there in Utah that know Corey and Eric that are watching the videos that are like, there is so much more to this. And I'm like, well, it's going to come out. It's going to come out. Do you think, well, it's not a federal case. I'm like, what are the chances that Corey Richards becomes friends with Jen Shaw while in custody, but Corey's in a different, do you think Corey's pissed that she doesn't get to go to federal custody with like the famous women from Utah that are in custody? Like, do you think she's mad? Because she was asking them to sneak her in Crest White strips into custody because she wanted her teeth to look better on stream. Like, I get it. I want my teeth to look better on stream, and then I forget to bleach them, and then I'm like, shit. But so like, I get it. But I think she's probably mad. I think she's probably mad that she doesn't get to be in custody with like Jen Shaw and Elizabeth Holmes and like some of the other defendants. Also, how many female defendants are we covering right now? Like there's a lot, and that's unusual generally in criminal law. I think that's why sometimes those cases garner more attention, because we're covering Corey Richards, Donna Adelson, Karen Reed. If Sarah Boone ever goes to trial, we will cover it. I'm just not, I don't have bandwidth to cover her 900,000 letters to the judge yet. Peter from Lawyer You Know has been doing that. But I'm like, what? Oh, she could become friends with Ruby. That's true. CK, this is a very good point. She and Ruby could become friends. Wouldn't that be interesting? And Ruby and Jody, like it's a lot. The judge and Karen Reed said trial will be Monday, Wednesday, Friday, full days, and Tuesday, Thursday, half days, if that helps. Mama Bug, it's going to help a lot for the team and for me to keep things going. And I was so thankful when I saw that. I was like, thank God for the half days. It's really what kept me going during Depp v. Heard is that they had Fridays off to do motions. It's going to be very helpful to do those half days for sure. For sure. Can we please catch up on the Scientology lawsuit? Christy, yes. The 700 page, look, blame Alec Baldwin. It's Alec Baldwin's fault. These 700 pages his lawyers dropped in that motion for new trial pulled attention there. So I have not had time to read and catch up on the Scientology stuff just because bandwidth. I do my legal research myself because I know, for me to explain things to you, I want to explain the information that I process through my brain and not just have somebody else write what I cover and read it to you. I have no beef with newsreaders. I think there are great newsreaders. I think at some point I will probably need some help pulling things. I'm just not there yet because I have offloaded so much so that I can distill the legal writing and research. But it's a lot and we've been very busy. So yes, we will get back to Scientology. I promise. Dr. B said the other Dr. B here. Hello, Dr. B. But yeah, it's going to take a minute. Wendy said, thank you for all you do. Can I get a shout out to the bestest bestie that ever bested? And fellow Leonard Sarah May turns the big 40 today. Sarah May.
Happy birthday. I think because it's the big 40, we need to just be like, go shorty, it's your birthday. You're going to party like it's your birthday. Have a wonderful birthday.
And happy birthday from your bestie, Wendy Queen. 40 is a lot of fun. I will just say 40 is, I found 40 to be a lot of fun. I mean, other than the fact that my knees sometimes make strange sounds when I stand up from my desk or go upstairs, like the brain is real happy at 40. The body sometimes not so much. Amy Z says you might not have an M next to your subscriber number, but you can quote clueless at the drop of a hat. EDB is Bay. Amy, thank you. But my 12-year-old is standing his ground on that, which is now just become a joke in our household. Christina said, so legalese is hard, bro. Yeah, right? Kimberly said, I know it's Friday, but chat needs to review the difference between permutations and combinations, and would be 16 possible combinations for A, B, and C, and D, 11 if you mandate an and. It was an and or, so it was quite a lot of different possibilities. quite a lot. Dicta is headcanon. I don't know what headcanon is. Don't revoke my nerd card. I don't know what headcanon is. Question, if the judge never ruled on objections, how can the objections be preserved? Nicholas, the objections are preserved even if the judge didn't really rule on them. I think you have a strong argument for that, saying the defense is like, I raised the objection, but the judge never ruled. Look, mess. The Great Big Geek said, are the sidebar transcripts out yet? I need the sidebar tea. From New Mexico, the attorneys don't even have the transcripts. So no, there are no transcripts at all. No transcripts. Mackenzie says, I feel like the lawyers skipped the class one day too many in law school. There is some basic things to lawyering, and distinguishing case law is one of them. I was very, very surprised. At how scant, threadbare, short the motion for new trial was. I was really, really, really surprised. Question, did you see where the press was dragging Prince Harry because he was mentioned in the Diddy case? He claimed access to him to lure people. I mean, I didn't see that yet. It's in the lawsuit that I'm going to be covering on the podcast. Look, man, lawsuits are allegations and shade. And a lot of lawsuits are written for press headlines, especially when it concerns celebrities. So throwing everyone's name into the lawsuit, A, it's in a lawsuit, so it's hard to take action about it. And B, it will grab headlines. And I think that's unfortunate. Anyone's name can just be thrown around in a lawsuit and there's not much they can do about it. It shouldn't be that way. It is that way. So if P. Diddy was actually using Prince Harry's name to be like, look at all the access I have, I don't think that's Prince Harry's fault, you know? But again, the press will press. For an extra monitor to do both. We can't listen to 2 court hearings at once. My brain will explode. Will this be the judge for the Baldwin trial? Yes. Nisha says Morrissey always seems to be scolding everyone. She has a very specific tone that makes a lot of us feel like we're being yelled at. I don't know if that's her or if that's us or if that's a combination of both, but yes, I often feel like I'm being scolded. Mujer Baroka said, what's up, Doc? Thank you very much for the callback. Have you heard Beyonce's new album, Cowboy Carter? Not yet. If not, will you? Probably. Love you and thank you for covering this on a beautiful Friday. You're welcome. New music also takes bandwidth for me to jump into, like processing new information. I have been re-listening to a lot of really loud rock lately. It's been like a Metallica-y type of week. So that's where we've been. Defense, proud, high five. Prosecutors, facepalm. Spicy Vet Med Geek said, I found out I'm coming to Nashville at the end of April, early May for Bestie's 40th. Thank you for everything, Ems. Go to Cross-Eyed Critters and have the best time ever. I will be in downtown Nashville. We will be putting this in the app. Ashley King said Nashville for CrimeCon. If you are in town for CrimeCon, I intend to have a Law Nerd meetup. I need to look at the schedule for CrimeCon to make sure it doesn't conflict with any evening activities at CrimeCon, because I would never want you guys to have to pick and choose. But I will be doing a meetup in the time that people are here for CrimeCon. It is my understanding that Runkle may come into town, Rob from Law and Lumber may come into town. And so as people are in town for that, we will be doing a Law Nerd meetup somewhere, like a Law Nerd night out. CrimeCon is the very end of May, like May 31st through June 2nd. So very end of May, beginning of June. Well, fingers crossed. We need the Karen Reed trial to be done so we can just CrimeCon. So whether or not you have tickets to CrimeCon, if you're in town, we will be doing a meetup. I will keep you in the loop on the app first and let you know here. And then we will do all the things. But we will be doing a Law Nerd meetup. I haven't figured out exactly what that looks like. My team has been asking me to. So I have some stuff going on there. So we will try to get everybody in the same place to just hang out. Really, the point of a meetup would be very much, hey, we're going to be in this place. Come hang out and chat with us. It's not going to be a ticketed event. We might need to sign up if we need to make sure that we have, depending on how many people, we might need to do that, but it's not going to be a ticketed event. It's not going to be a live podcast recording. It is very much going to be a get together with other people who like the shit you do and have a drink, get hydrated, and have a conversation. That. So we're going to do that. Let's see. How many lawyers can we fit in Emily's office? No, we're not collabing. We're not collabing. So even if you don't have a ticket to CrimeCon and you are in town, we are going to be doing a Law Nerd meetup. Amy, are you coming into town? That will be amazing. All right. Daniel said it would help Bowles if he showed up as a CAD. I don't know if that's true. It would be funny. Carrie Jo asked if I'm speaking at CrimeCon. I have a conversation with them next week. They had not asked. It seems to me that CrimeCon was very podcast focused. I mean, I have a podcast, but we'll see. Maybe not. I don't know. But that is not their schedule might already be set. I don't know, but I will be there. I want to hear Maya is speaking, and I would really like to hear Maya, her attorney, and them speak. So Grass Folk said, do you ever sit in the chair behind you? If so, what for? Yes, that is my reading chair. If you can see, I don't know which way I move. If I go this way, like my laptop and my lap desk are there right now because I was doing work from the chair. So yes, I do, because I can see out my window from the chair very well. So yes, I do sit in the chair behind me when I can. Bowles reminds me of the head pixie from the Fairly Odd Parents. I think she could use a new trial because horrible lawyer, but his appeal makes no sense to me. It just doesn't fit. That would be appellate counsel would have to come in and make that appeal, and that might not be something that she wants to do. She gets to make that decision. My opinion is kind of irrelevant in all of that. Midnight Wolf 2100 said, Emily, just wanted to say that I found you with the Depp case and you got me into law. I'm in my last semester for a paralegal program and getting my bachelor's in history. Not sure about law school yet. Look, law school can be very expensive to engage in. Paralegals, good paralegals, have gotten very hard to find. There might be a lot of room to do, especially if you're not like, I need to be in court. There might be a lot of room for doing paralegal work without incurring the debt of law school. And you can always choose law school down the road if you want to. There were a few that had been paralegals at law school, and I think the entire first year of law school, they're like, yeah, I know. Yeah, I know. Yeah, I know. But good paralegals not only can create exactly the career they want, but they can work with lawyers that they very much respect because they are hard to find. I'm actually speaking at a paralegal conference here in Nashville at the end of April. So Amy, it's good to see you. How are you feeling? I'm going to text you after stream. Firefly said, is it concerning that the judge is so against giving her release? Does that indicate a longer sentence will occur? No, to me, Firefly, it doesn't. I wonder if the judge is already contemplating a time served release, but I think the judge is like, this hasn't been decided yet, so the request is premature. But no, it doesn't concern me. But I don't practice in New Mexico, so what their typical sentencing scheme is really hard to try to foresee. Corey, thank you so much for the memberships. I'm sorry that we keep saying your name so much. Blame Corey Richens. Tree Hugging Hippie Mom has been a member for 16 months. Congratulations. EDB, I'd love to interview you before May. Wildness RK, if you've emailed, I will ask the team about it. We've been having trouble getting calls on my schedule right now. It's been wild, but I will see what the team, if there's an email, I will take a look. Elizabeth said, Substance 10K, love this Law Nerd family. Me too. The Law Nerds are the greatest nerds. We are also, I am now convinced that we need Clandestine Chemistry band shirts, and it's our Law Nerd band. You guys decide what you want to do in the band. It's going to be a really big band, but I figure the Law Nerds can just be Clandestine Chemistry. It's great. Now I have to decide if we want like molecules or beakers. So we will be we are working on that. Ann said, I'll report live from the courthouse in Dina, Mass, outside the 500-foot perimeter the prosecution is asking for. They're asking for a 500-foot perimeter. That's unusual. But there's a lot going on with this case, and I'm sure there will be protesters for sure. Cindy said, you encouraged me to go back to college. Yay. Gonna be a paralegal. You taught me to love the law, and I can't thank you enough. Cindy, that's amazing. Again, good paralegals, especially in civil law, keep things running. But there are so many options when you become a paralegal, especially if you are interested in going into the criminal side. There's room in both defense and prosecution offices for paralegals. There's room in civil for paralegals. Find the thing you like. You will find work. There is a tremendous amount of difficulty to find people who are experienced and good at what they do. Thank you for making the law make sense and fun. I hope to always do that. I hope to always do that. I just pre-ordered Onyx Storm and got Warren's book. Amazing. And I know exactly what you mean by Onyx Storm. It's all I saw on my Instagram feed yesterday. If you know, you know. And we are not looking up his nostrils either. True, he did a little bit of a better job today with the angle. It's hard. It's hard to get the right camera angles on Zoom. Ashley said, is there a way to chat and connect with other law nerds going to NSH with updates and meetup plans due to the ticket price? I would make this a solo trip. Ashley, I'm not sure what, to Nashville for CrimeCon. We are working on extending that in the app. I don't know if we will be able to by then, but the app, I'm going to keep information in the app. But we are working on a way for law nerds to connect in the app. So that is something that we have been working on, but we will be putting things up in the messaging spot, and that is where the meetup plans and stuff will be. Krista said, is dicta the legal equivalent of showing your work in math, but it's not the answer? I think that's a good way to explain it. Dicta is the thinking out loud, but not the final decision. Yes, Krista, I think that's a really good way to summarize it. I'm kind of jealous of how her hair looks despite being in prison. Better than mine, Jess. I mean, it's been a week of hair up and a hat. Like, yeah, it's yes. Are you planning to do a meetup inside of CrimeCon or an outside event? Outside tickets are pricey, but I also hear that Rob and Ian are planning to go. I would only go to meet you guys as well as my fellow law nerds. Ashley, outside. And for those of you that are thinking about this, I will say, if you want to go to the event, go to the event. But the hotel where the event is a massive hotel. And so you can be, I would imagine, easily in and around the hotel without needing a ticket to go into the conferencing portion of the hotel. The Opry is a massive hotel. So there's lots of places to hang out and be around the hotel. So I'm not going to say there aren't other conferences that I have been to where I have never even set foot into the conference and spent my time in the hotel chatting with people. That is often my conference. That is often my conference experience. You also don't need rooms at the hotel to go to the hotel and hang out. The hotel is itself a destination. So the Opry is huge. So you can go hang out at the Opry. And if you have, law nerd stuff on, the law nerds will see you. But I think you could probably do it that way without necessarily having a ticket to the event. Don't tell them I said that. But it's huge. It's a whole destination. So even if you stayed off site, you could easily go in for the day and hang out at the hotel and see everybody walking in and out. If I go into the event, I will be going to see Maya speak. I will look at the other people who are speaking, but that's what I want to see. And then Opry is really close to Opry Mills, which is a massive mall. The new Ryman is right down there. Like, there's a lot to do. Jordan said the inside auditorium is incredible, and there's restaurants and it really is a destination in and of itself. The hotel has different wings, but the middle part of the hotel, there are different vibes. There are restaurants, there are bars. It is a large resort destination, but it's all inside. It's pronounced Dedham Massachusetts kills me. Look, my first year at UMass Amherst, I'm like, I don't know how to pronounce any of this stuff. Like that, you say Worcester, but that has a lot of fucking letters in it. Like I can't. I'm so bad at Mass names. But if I start Mass accenting during this trial, it's going to throw me back to Emily in college when at every single party I went to, people were just like, oh my God, where are you from? Like, California. I think I was one of like 5 people from my freshman class at UMass Amherst, which is a fucking huge university, that were from west of the Mississippi. It was not a school that had a lot of the West Coasters coming in to go to school, for sure. M said they're all girl bossing their way to prison. I mean, that kind of summarizes most of the cases we've covered, especially now that we've got those financial crimes on Corey Richens. No need to tell Reed we're now talking about dicta. Oh no, we're not. We don't talk. Reed doesn't need to know. Reed's going to be like, what is happening on your channel? Motion to add Lawnard band shirts to the docket and add tour dates, destinations. Amy, we have been working on those. It is actually in the works for Lawnard tour shirts. Yes, in the works. Let's see. We've got so many things. I'm going to get to a few more questions and then we're going to wrap. It's been a long week and I've got to start prepping podcast. Raven says, sounds like a casino minus the gambling. Yeah, it's a full destination, the Opry, but it'll be fun. So for those of you that are in town, yes, I understand the tickets are expensive. I get they're definitely not as expensive as like a BravoCon, but it's not inexpensive. I think the base level tickets are $400, I think. So if we can get a Lawnard discount, I don't know how many tickets they have left. Again, I have a conversation with them for next week. I don't know how many tickets they have left. But if we can get a Lawnard discount, I will absolutely ask. But yes, I'm sure the hotel is already kind of booked because there's multiple things going on at that hotel at all times. There's also like an indoor water park, like so much stuff. And the schools around here are done with spring break, but other people come here for spring break. So I'm sure there will be people at the hotel just to use the indoor water park because it's a destination. Like it's a lot of fun. We've done that for my kid's birthday. Oh my God. We did the Opry for one of Griffin's birthdays and I didn't realize that they were going to park my car outside. I don't know why I didn't realize it. I just didn't realize. I didn't even think about it. So we had a massive snowstorm coming in and I was like, okay, like if we leave at this time, the roads shouldn't be too bad. So we're there for Griffin's birthday. His birthday's in early February. We're there for Griffin's birthday. We're doing the water park, the whole thing. That's what he wanted to do for his birthday. He wanted to stay at the Opry and go to the water park. Perfect. So we decided to leave a little bit early because of the weather. They were already having issues at the hotel with restaurants being shut because people couldn't get into work because of the weather. So we knew it was going to be an issue, but trying to get my car to deal with weather was not great because it had rained and then frozen. This is not something I ever experienced living in Southern California. So for those of you that live in places where this is not unusual, my car was literally a freaking ice cube. It was just an ice cube, but the Tesla has doors that go like this on the outside, but there's no way to make the doors go like this when your car is ice cubed. Do I have ice scrapers in my car the first year I've moved to Tennessee? No. Do I have any way to try to get the ice off of my car? No. Do I have any perception of how bad the roads are going to be? No. So I don't know how they got into my car because the car also doesn't have door handles. You can't just like physically pull the door open because it's all buttons. Look, if you live in particularly cold climates, electric vehicles are probably not for you. The other problem is what happens in the cold with batteries. They fucking drain. So not only do I have no perception of how to deal with my car in cold climates, because this was right at the beginning, we now have ice scrapers. I am now much more aware of how to deal with it. Tesla's improved. They're winterizing. I don't think it's a car I would drive if I lived somewhere where we had more cold days a year. Like if I lived in the frostier north, I don't think this is a car I would have ever purchased, but I love my car. So there was so much ice, and my battery, and they did not at the time have a charger. My battery was not going to get us home. So we had to get to a charger to deal with the car. But I could not see very well out of the windows or the side windows because just sheets of ice. At one point, I made the mistake of turning on the windshield wipers. Don't do that because they are just going to break. And I tried to roll down the window and just got a sheet of ice. So I'm able to see barely enough. The roads are iced. We get to the supercharger and I am sweating. I am so anxious. I start charging the car and it is charging so slow because it was so fucking cold outside. I slip on the ice because I'm wearing UGG boots. Look, when I left Southern California to go to the University of Massachusetts, the winter boots I took with me were UGG boots. I learned very quickly that UGG boots are not, in fact, winter boots. They are really made to go surfing in the morning where it's cold to keep your toesies warm and to put on after you get out of the pool from a swim workout, because in California, our pool was outside for a lot of the pools that we used. And so I put on my UGG boots after swim workouts and kept cold. But they are not fucking winter boots. They have no tread. They are not waterproof. They are made for not winter weather. So in college, I tried to go to morning workout in my UGG boots, like the first time it iced at UMass. Me coming from Southern California, it's not like I could Amazon shit. It was 1996. So I have my UGG boots thinking that they're winter boots. My parents weren't just like, you need other boots. Mom, we're going to have that conversation later. I don't know what happened. It might have been me. It might have been like, I'll be fine because 18. And obviously, fucking everything at 18. So I'm like trying to get to morning practice to the pool. The women's team had the far pool, a whole separate conversation, not the close pool. So I'm trying to get to the far pool in the morning from my dorm at, I think practice started at 5. So it probably was like 4:30 in the morning. I was not the only one heading out to morning practice. There were lacrosse players that were heading to morning practice. The way I ate shit in my UGG boots, just all of my shit was everywhere. And this was leaving the dorm for like the day because I had to go to practice, get food, and then go to class because there was no time to get all the way back across campus. It's a big campus. No time to get all the way back across campus back to my dorm in between morning practice, breakfast, and morning class. So for those of you asking, did your hair freeze? All the time? Like I would put on a beanie, but I would try to keep the beanie from getting too wet because I had to wear it to class. And so the hair sticking out of the bottom of my beanie was frozen. And then you would sit in class and it would drip down your back because the classroom was 97 degrees. The outside was -10. So I ate shit. The lacrosse players were laughing at me eating shit because obviously I remember calling my parents and being like, we have to get some clothes, but I don't have a car. There's nowhere to go shop. I can't order things online. That's not even a possibility. Like I was lucky we had AOL chat rooms to stay in touch with my friends. No cell phone. So we're going through like the fucking LL Bean catalog to try to find a jacket. And I'm like, okay, well, it seems that everyone here is wearing this particular barn coat from LL Bean. Literally everyone. And they're using these backpacks because the fucking zipper on my backpack would freeze shut. So I'd go to class and not able to open my backpack because my JanSport would freeze shut because it had a metal zipper. Nobody said, oh, by the way, you need a backpack with a plastic zipper. Who even fucking thinks that you need a back, not just with a plastic zipper, but with a flap that goes over the zipper so it doesn't get wet and then refreeze? So I'm like, Mom, I need you to order me boots with the fur, kidding, boots with tread, a barn jacket, like a scarf, and a backpack that's not going to freeze. I was so unprepared and you know what? I survived. I mean, I think it was the beginning of how I hurt my lower back was eating shit that particular time with the UGG boots. The way my feet came out from under me. So that is reiterated as I am leaving the Opry with my family, completely unprepared for my car to be a goddamn ice cube with like push buttons. I can't even pull the door open because they're fucking push buttons. So we get to the charger and I am like using my hand like this to try to scrape off the charging port because the charging port on the Tesla will not open because my car is an ice cube. I would have rather somebody put it in Jell-O. Iced. So we finally get the charging port open, get the car charging. I try to walk to the grocery store that is right there to find like a spatula or a ice scraper. Silly me. There's no ice scrapers left because people knew that the storm was coming. I now know when storms are coming. I follow Nashville Severe Weather on Twitter and have 5 weather apps. But I was unprepared, shockingly. So I get a spatula, like a plastic spatula, and I'm spatulaing the ice off of my car where my children are like sitting in the back of the car, like, I'm sure contemplating, is this how we die? Like, is this how we die? Frozen into this Tesla in a parking lot. No one is on the roads because everything is iced over. And we're like, okay, we're going to charge the car enough to get home. We're going to get home and we're not leaving. The problem is we had been on vacation. So at this point, I'm realizing we probably need some groceries because we're going to go home and everything is snowed in. So trying to like figure out exactly what snow snacks we're going to need, how long we might be. That spatula is still in my car, by the way, how long we might be snowed in for, because they don't, Tennessee doesn't exactly believe in like snow plows except for like 1 or 2 major highways. So my neighborhood, it does not get plowed and has enough of a incline to get into my neighborhood that when it ices, it slides. So I'm like, we kind of need groceries. And this is where I am trying to bring the base level groceries out of the store in my Ugg boots on the ice. And I'm literally coming out to my car going, it was bad when I fell when I was 18 in my Ugg boots on the ice. Like, I am in my 40s. I have had a spinal fusion. I can't go out like this. So I have never walked more slowly, but it's fucking freezing. I've never walked more slowly trying to get back to my car. By the time we got home, I was A, ready to cry, and B, I'm sweating telling this story again, completely drenched in sweat. I was so stressed out. We made it home safely. Griffin was like, that was the best birthday ever. Where was Dr. B? Dr. B was in the car. Dr. B has had some nerve damage to his hand. I was like, Dr. B, you're staying with the kids. Like, if you fall and hurt, if he puts a hand down and hurts a hand again, like, it's over. So he was dealing with other things that I was like, what are we doing? So that was our first snowed-in experience in Massachusetts. Our neighbors, when we got back, had texted the group text of our neighborhood because it's a small enough neighborhood that we have a group text. Our neighbors had texted and they're like, so as you all know, we recently moved here from Michigan. Does anybody need anything? Like, are y'all okay? We're like, we're not okay. So we were then ordering scrapers. All the cars are now more prepared for weather. We just weren't prepared for weather. I didn't think about it. We were prepared for rain. We were prepared for, what are we going to do in the event of like spinny weather? We were prepared for other things. We were not prepared for icing over. We're now very well prepared, but our Michigan neighbors were so helpful. The Michigan neighbors checking on we have a family in our complex from Kansas that was much better prepared than we were. Texas and the Texans and the Californians were not well prepared, and our neighborhood has multiple Southern California families. So we all moved into this neighborhood around 2020. So we were all fairly new to Tennessee at the time, and we're just not prepared. Carol C said, do you have a generator for your house? We do now. But the cars now also have like blankets and scrapers and all kinds of other prepped stuff. We're now more prepared for weather, but you don't know, because in California, I was prepared with like go bags for earthquakes. Like, what happens if there is an earthquake while I'm at work and like the freeway that I take home collapses? I was prepared for that kind of stuff. Wasn't prepared for this. But anyway, I digress. Anne said, I once got lost at the Opry Hotel for 2 hours. I was not staying there. And Massachusetts pronunciation is a separate language. It is, and it's very I think Massachusetts is like, we're going to be able to tell who's from here and who's not. Bop It, do we not have, we have Leonard University stuff on mugs. I will take a look about shirts. There might have been a printing issue with the design. So I will take a look. Learn Knitting Now said, how can this Supreme Court decision apply here if it happened after her conviction? Are all past cases affected now? Yes, they can be. They can be impacted. But it's also an argument, and defense is going to make arguments. It's a very specific level of impact. But I would, if I was a defense attorney who had a previous case that was very similar to the case that was just overturned, I would ask for another motion to reconsider overturning the case. But yes, it can impact other cases. Destiny said, I made that mistake in middle school, except I'm born and raised in Ohio and should have known better. Frozen toes all winter long. I was more embarrassed that like the guys that played lacrosse were laughing at me than I was about how badly my back hurt until years later, where I was like, oh, me falling on my ass multiple times in college because of snow was probably what started the disc issues in my low back. Like, but I had multiple friends in college that literally had back injuries from falling, doing different shit. I was like, how are we all hurting ourselves? Like, we're 18 and you kind of push through. And then later in life, as you get older, you're like, is that injury still impacting me? Yes, it does. Yes, it does. Yes, it does. Things I'm trying to teach my kids now. Just because it might not completely fuck you up now does not mean that's not going to hurt when you're 30. It absolutely is. Thank you, Miguelina, for dropping the links for the Law Nerd University shirts in the shop. We're going to do that real quick. So I am definitely more cautious with my footing than I used to be. I used to think I was invincible. Guess what? You're just borrowing. You're borrowing from future you. 18-year-old me who's like, I'll keep playing through a torn rotator cuff. No, you're borrowing from future you's ability to use your right arm is what you're doing. That's not a great idea. All right, let me go ahead and share my screen real quick. So in the Law Nerd shop, let's see, when you go to lawnerdshop.com, you will, where did it go? Share screen. Why are we being salty? It's my own shop. Stop it. Let's try it one more time. We're professionals. It's like, it's Friday, boo. We're kind of done with, we're done with the things because it's Friday. It doesn't even acknowledge that it's pulled up. That is so rude. Chat could be 30 seconds. All right, let's see if this works. Maybe not. There we go. Law Nerd shop. This is the Law Nerd University tee. We also have it embroidered, I believe, on a hoodie. The thing about the Law Nerd shop, if you guys aren't familiar with the Law Nerd shop, if you want to, and again, if you want to, you can search by type of thing, but you can also, if you want to go through and look by design, you can look by design. Law Nerd University is called Law Nerd University. So you can search through things depending on how you want to find them. You can also search up at the top if you want to. Law Nerd, spell it right, Emily. Type better. So you can search for design as well and see all the different things we have in a given thing. So Law Nerd University in V-neck or crew neck, and stickers and mugs and mega mugs and travel mugs and all the rest of the things. So that is up there. So if you ever are looking for a specific type of design, you can just search it and see all the different products in that design. And you can also search by the type of thing if you're looking for a mug or what have you. So that is one way to do it. Thank you, Miguelina. I think we had tested one out. I'm going to look about adding it. But for those of you that have asked about the Law Nerd shop, you can also shop by type down here at the bottom. So you can look through the different collections. I'll see where the other ones are because we have other collections that we had highlighted. So, I'll find those. Do we run the shop ourselves? Yes, we do. But we do run it all on Shopify, which is why they are a sponsor on the podcast, because they really made it easy. Emily, are you coming to Friday Night Frenzy with Lawn Lumber tonight? We have some family plans tonight because the kiddos have shorter school days. So I will probably pop in to cause chaos in the chat, but I can't stream. We have family stuff. And by the time we are done with family stuff, I'm going to be prepping and reading. So, let's see. Kelly D, EDB. Would you be friends with Carrie or mortal enemies? Well, I don't think I have any mortal enemies. There's not much that is that deep. How would your styles mesh, or would Bowles be a better option as a co-counsel? I don't think I could co-counsel with either of them. Like, for me to co-counsel with anybody would take quite a lot of trust and work and knowledge. So that would be very difficult. I would have to know them, because how people behave in court and how they behave out of court can sometimes be different. And I would just have to know them. But I thought Carrie's cross-examination was great. But for me, with working with co-counsel, the prep style and the court style matters very much. And it's something you just have to know, people. The prosecutor was allowed to make all kinds of new arguments on redirect during the trial, and the defense didn't object, but they should have. Like, they totally should have. It's going down when it comes to trial again. Christina S. said, I was going to go to Fall Out Boy for my birthday this weekend. Can't. I have knee surgery Monday. Oh, no. Thanks for taking my mind off things. Happy Good Friday. Christina, I'm sorry for your knee surgery. I went to see Dave Matthews in Vegas after having my ACL repaired. It was not easy at all. It was not easy. I did it, but it was not an easy thing. So good luck with your knee surgery. I'm sure recovery will be good. The best thing when I did my ACL surgery was the big sleeve with the iced water that cooled it. 10 out of 10. 10 out of 10. But yes, I will try to come Chaos Gremlin in the chat just a little bit. But not streaming. We're going to do family stuff. Right. With all of that, law nerds, I didn't mean to digress into Emily being unprepared for weather that exists, but I was. Like, I didn't even think about it. The problem is you don't know what you don't know until you know. And sometimes those experiences are more difficult than others. So we are working on putting up a docket in the app. It might change form a little bit, but we might do a rudimentary so you guys can like plan your life. I get it. Us too. We have not yet found a way to do some of the things we want to do, but we have stuff rolling out to the app that I'm really excited about. And we're like so close. I'm just like, we're so close. So if you're not signed up for the Law Nerd app, lawnerdapp.com, free app in your app store, easy to use. It's where I'm going to be doing updates on stuff. I did updates yesterday on the new stuff that came out with Murdaugh that I didn't update anywhere else. So that's what's there. And of course, reminders for the streams, what we're covering and when. It's going to be very busy between now and I don't know, like July. So we're bracing ourselves for another 5 to 6 weeks of trial. But in all of that, we have lots to do. So Law Nerds, thank you for being here. Thank you for being Law Nerds. I hope for those of you that celebrate, you have a good Easter and a good Friday and a good weekend. Take care of yourselves. We have a busy week next week, and I will see you soon. Bye, guys. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.